What do you do if stopped by the police? What do you do if pulled over and asked to breathe into a breathalyzer? To answer those questions and many more, we have with us here today Attorney Zaki Tamir from the Tamir Group. Counselor, thank you for joining us here today.
Thank you, Clark. Good day.
I've been getting so many calls about these questions. Police interaction. We had a union official. We had two union officials from the law enforcement arena, and we spoke about police interaction. Tell us a little bit about, first of all, yourself. You're an attorney. Give us a little bit about your background.
Sure, I am an attorney. I work here in New York City. I do have to just give a small disclaimer before I start.
Absolutely.
That I came here to discuss this matter, which I think is a very, very important matter. I'm here to demystify communications with law enforcement in general and police officers in particular in New York City. But none of the information that I give today is actual legal advice. I'm not giving any legal advice here at all. I'm here to discuss mainly human relations. What are your expectations, when you're dealing with law enforcement, when you're dealing with police officers, when you're dealing with the DA's office and a prosecution, or even with your own attorneys and family? What are you expected to do and how are you expected to behave? There's no attorney-client relationship being established here in any way, not with the public or any particular person, and not with you or not with any other individual or entity. So, but I am here for the discussion, though.
Duly noted. We appreciate that.
Thank you, sir.
Police officer approaches you while you're walking down the street. Does that law enforcement officer has the right to stop you? And if he does, how does he articulate that stop?
Okay, so firstly, there are a police officer to stop you in New York needs a reason. Okay, there has to be a reason why he's stopping you. That reason is not allowed to be based on race, religion, national origin. It's not allowed to be a profiling, reason. However, we have to always make the distinction. And I tell this to my kids also, and I tell it to my clients, and I tell it to people that ask me, and discuss the subject. Whether it's a car stop or whether it's a pedestrian stop, a certain distinction has to be made between what are my rights, meaning what is a police officer allowed to do and what is he not allowed to do. That's on one end of this evaluation. And the other end of the evaluation is, what is my response? What is my permitted response? And I'll give you an example, boy, what I mean by that. If a police officer stops me in a car, let's say for argument's sake, he stopped me for absolutely no reason. He stopped me because I'm Jewish. He stopped me because I'm black. He stopped me because I'm Hispanic. He stopped me for an illegal reason, let's say. He says to me, "Can I search your car?" I say, "No, you cannot search my car." Now, even though the police officer, whether he's allowed to search your car or not search your car, has nothing to do with whether you gave him consent. Your consent, or whether you gave him consent or didn't give him consent, is only effective as to whether or not that search, the results of that search, will be admissible in court. So, if a person has a kilo of cocaine in his trunk and he says, "I don't give you permission to search my car," the police officer searches the car anyway, okay, finds the cocaine in the trunk, arrests the individual, puts him in for the night, goes in front of a judge the next day. Now there's a case against him in New York. He's being charged with drug possession. Before he goes to trial, there's going to be a hearing, okay? A hearing with respect to the search and seizure. Were the constitutional rights of the defendant violated? And is that kilo of cocaine fruits of the poisonous tree?
To the poisonous tree.
If it's found that was fruits of the poisonous tree, that cocaine was after the results of an illegal search, it's going to be suppressed. They're not going to be allowed to use that as evidence in the case.
In that case.
So my point is, when the police officer stops you and says, "Can I search your car?" you say no. If he says, "Pop your trunk," you pop your trunk. You still comply. And there's a human level over here, and this is whether you're a pedestrian or whether you're a driver. The police officer ultimately makes a decision at the end of the day as to whether or not he's going to search your car, whether or not he's going to arrest you. The DA's office is later on going to deal with whether it was a legal stop, whether it was a legal search, whether it was a legal arrest.
Okay.
Now, the person being stopped has one major tool that they could use, weapon they could use in this transaction or in this encounter with with law enforcement that proves to be the strongest and most effective thing in any one of these transactions. And it's called humility. It's an amazing, powerful thing. And you see it sometimes with the basic tickets, a cop stops you, you're speeding at like 90 in a 50. Not that I ever did that.
Right. Duly noted.
If a person is doing that.
Right.
And, the police officer comes over to the car and says, "Do you know why I stopped you?" And you're like, "Absolutely not. I have no idea." It's a little bit insulting to the police officer's intelligence to say, "I have no idea why I was stopped." Right. And think about it as an older brother. And I say an older brother or an older sister as opposed to a parent, because I think that parents tend to look a little more kinder on their children than older siblings look at their younger siblings.
Right.
But if you have an older sibling and it says to you, "Hey, you're speeding," and you say, "No, I'm not." Or you say, "What are you talking about? I try to lie."
Right.
It's just, you're pinning the police officer against you in that first second. Now, there's another part of this that deals with how do you prove that you didn't give consent? Meaning, if you want to make sure to get it clear that the police officer asked you for consent and you didn't give consent, you want to preserve that for later on. Today's day and age, we have video.
Correct.
Obviously, you can get it on some kind of recording, whether it's a voice recording, audio recording, or whether it's a video recording, confirming that you didn't give consent. So obviously, if the police officer asks you to search your car, and you say, "No, I don't consent," you can, record yourself not giving consent, making it clear. You could also ask for an attorney and say, "Look, I don't want to say whether I give consent or I don't, but I can tell you one thing, I don't want to do anything until my lawyer comes." Because you have a right to consult with a lawyer and say, "Listen," you can speak to somebody and say, "Listen, Mr. Lawyer, I have a kilo of cocaine in my trunk, what should I do? Should I consent or should I not consent?" Or you could call a lawyer and say, "Listen, I don't have anything in my trunk. I just feel violated by this police officer stopping me because, of my national origin or because of my religion or because of my race or creed. So I'm not interested in giving him consent. I want you to be here." And the Constitution allows us to have that. We have that right to have an attorney present.
Is it, just to ask this piece, is it legal to record the interaction?
There is no specific law that I know of that prohibits a person from recording interaction with police. I think that now it's becoming more and more common, even from the police side, to record it. They have body cams. And in many cases that I've dealt with recently, that that video footage on the body cams has proven to be very, very valuable evidence in the case and how things went down. Now, even on the prosecution side, when you're dealing with a case, the way that you deal with the case, the way that you handle yourself throughout the transaction and the dealings with the police and with the DA's office and with the judges and with the juries has a very strong influence on your case. Now, a lot of times people mistake certain statements and admissions as being, forthright or honest, and you can do all of that. But if a person is really concerned about a particular crime that they're involved with, God forbid, or they're involved with something that they're concerned could put them in serious legal danger, they should have advice of an attorney with them at the time, which they have a right to, at the time before they make decisions about whether they should speak, what they should say, how they should present themselves. A lot of times it's simply a matter of turning themselves in. Police officers will call me, and my experiences in the DA's office, I started off as a prosecutor. When I've gone into, in Brooklyn, I was in Kings County. It was very, very good experience. It was amazing. It started off my career in prosecution, and then changed over to defense, a few years later. But besides for the actual law and knowing your rights, an attorney is also able to advise you about, look, this is the way to go at this point. The police are reaching out to tell you, hey, you can turn yourself in now, and you can in effect say, okay, I did this. What is the best way to deliver the message to the police and to the prosecutor or to the judge that I'm sorry for what I did. I want to know if there's some way that I can, get a offer to be able to resolve this matter with the least amount of damage to myself. And you know what? In crimes that are non-violent crimes in New York, there is like the best system here that's growing in the past few years. It's just gotten better and better and better, like different alternatives to jail. Different alternatives to jail, different alternatives to deportation, alternatives to criminal records, especially in Brooklyn. I mean, Brooklyn is, very, very understanding and helpful with so many different programs and so many different opportunities to defendants to really get on the right track.
Right. Now that we mentioned Brooklyn, say hello to DA Eric Gonzalez.
Yeah.
He's a good man.
Very, very, very good DA. I mean, he's really, really unbelievable. I mean, he has really a heart. The perfect combination between somebody who's tough on crime, but really understands each case like it's an individual case. Like gives it the real care and attention. Because listen, there's who knows how many cases. Brooklyn is like huge.
Right.
The kind of cases that come through there, to be able to give it the type of tailored attention to each case is just an amazing, amazing feat. That it's just like it's a miracle how he was able to find that balance, and also the sensitivities of every type of community and every type of neighborhood and every type of, and taking all these things into consideration it's a balance that has to be perfected on a constant basis.
Right.
You know what I mean? It's not like, okay, I got there, we're good. So, I mean, we're very fortunate in Brooklyn. I'm from Brooklyn. I'm very involved with my community in Crown Heights.
Yes, you are.
And it's really, really amazing to have a DA like that. I got to say, this is coming from the defense side.
Correct, correct. Does that trickle down to the ADAs?
Absolutely. I mean, the DA brings, whoever the DA is at the particular time or whatever, county it's in, has a major feeling on the vibe, the positions they take, what they're strict on, what the DA's office is not strict on, what the ultimate decision is on cases that are more political cases or cases that are getting a lot of attention because they have to do with policy of New York City as a whole. I mean, there's some basic examples of things that are like really bother me in places like Queens, for example. Over there, they have this policy where if a defendant who's arrested for a felony doesn't waive his right to 180/80, which is that he has to be indicted within 6 days or else he gets released without bail, then the DA's office doesn't give him an offer. That's something it's very disturbing to me, and it really, it's unbelievable that they can just make that as a policy of the office. I mean, no offense to Queens or to the DA there, but this is a policy that's been for many years in Queens, and it's just, I think it's an awful policy.
We're learning so much today, and we're gonna, don't go away. We're gonna come back from the break. Is driving a right or is it a privilege? On the other side of break. Welcome back. I'm Clark Pena, and this is your Advocates Corner. Had a great conversation earlier on the other side of the break where we spoke about police interaction. And we have with us to discuss, is driving a right or is it a privilege? We have Zaki Tamir from Tamir Law Group. Welcome back.
Thank you.
Is it a right or a privilege?
So for my, again, I'm not giving legal advice.
Absolutely.
But I'm here for the discussion, and driving is not a right. We don't drive. Our driver's license that we receive is exactly that. It's a license. We receive a license as a privilege. So that becomes the most relevant when somebody gets stopped with allegations of driving while intoxicated or driving while impaired.
Okay.
Or driving under the influence of any kind of substance, even if it's not alcohol, something that impairs the mind in any way or impairs judgment in any way. And I say that because when a person gets stopped and they're asked, typically they will be asked to blow at the scene, a breathalyzer at the scene. That breathalyzer is not very reliable. It's therefore not admissible in evidence, meaning later on, whatever a person blows at that scene is just really to give the police officer kind of an idea of where you're holding, like, how drunk is this guy? The reason why it's not so reliable is because if I drink a tiny sip of beer,
Okay.
if I drink this cap full of beer, but instead of swallowing it, I swish it around my mouth, and I take a breathalyzer at the scene at that time, it's going to show my blood alcohol content probably above the criminal level, which is 0.08. If I refuse to blow, the police will automatically, the DMV will automatically, based on the police, informing the DMV and informing the judge that I refused to blow, will automatically have my license suspended, pending the case. Okay? Now, at the scene, the residue in your mouth is very, very potent. It takes a person probably about close to 25 minutes or 20 minutes until the alcohol actually gets into his blood alcohol content. If a person does have just a tiny sip, if a person goes to church or goes to synagogue or goes to a service where they're drinking a tiny little bit of wine or a tiny little bit of beer or something, they should make sure to wash their mouth afterwards. So if they do get stopped, that they're able to blow, and it doesn't come out indicating that their blood alcohol content is off the charts.
Okay.
Now, because the blowing at the scene, that breathalyzer at the scene is not admissible, what the police will typically do is take you to the 7-8 precinct. There might be another precinct also that they take you to.
Manhattan is a 2-8. Yeah.
The 28 precinct that have the actual machine, the breathalyzer machine, the more reliable one that a person is given an opportunity to blow into. And the police will actually videotape the person at the time that they're being asked whether or not they agreed to blow into the breathalyzer. That machine is a lot more accurate, but there have been attorneys that have argued to the jury, and I've seen unbelievable arguments in this area, that white bread or other substances can make it appear as if there's blood alcohol in my blood at higher rates than it actually is.
Really? When you say white bread?
White bread, regular white
Really?
bread.
Okay.
And a lot of these things, are, a lot of times people don't want to blow for different reasons. First of all, before we go into this, and I'll tell you what the legal level is, what's criminal,
Okay.
and what's legal. But before we go into that, I want to just clarify one thing. when we talk about this, and I always try to do this when I talk to my clients even, or when I talk to my family members or my kids, I say to them, look, you want to do an analysis about what you have to do and what your rights are? No problem. But look at it from the eyes of the victim of a DWI.
Okay.
While you're thinking and doing this analysis, imagine that you were hit, God forbid, walking down the street with a walk sign and got hit by a DWI, got hit by a drunk driver. Now do the analysis about what you believe the policy should or should not be.
Right.
Now, the policy is a very, very strict policy in general in all the boroughs, especially if there's an accident or injuries or anything like that. It's something which it's a devastating thing. You're talking about innocent people that are getting harmed from people that are literally getting into a car irresponsibly. And people think that, a lot of people know that the criminal level of blood alcohol content is 0.08. Okay, 0.08 is approximately 4 drinks. Okay, and what I mean by drink is 2 ounces of a spirit, which would typically like vodka or scotch, which would typically be 80 proof, 40% alcohol. So if you have 2 ounces of a spirit, it's equivalent to 8 ounces of wine, which is a typical wine glass.
Okay.
So a shot of a spirit compared to 8 ounces of wine, which is typically 13% alcohol, somewhere between 10 and 14% alcohol. So it will typically also 8 ounces of wine will bring a person up to 0.2.
Okay.
And 12 ounces of beer, which beer is typically like 5%, 6%, alcohol, the typical beer. So either 12-ounce beer, 8 ounces of wine, or a 2-ounce shot of spirit will bring you 0.2, which means that it takes about 25 minutes to set in. So if I go to a wedding and at 7 p.m. I have 4 shots, or 1 shot, 2 glasses of wine and 1 beer. Okay, I don't know how healthy that is, but let's say I do that.
Right. It's a wedding.
Right. So that will bring me to approximately 0.8. Okay. Now, a lot of people's bodies process differently, but there has to be some kind of gauge, and this is pretty much the gauge that I use and that I've learned about, that it's more or less talking about 4 drinks is going to bring you to criminal level. Now, even if you're 0.02, you can be stopped and arrested. Alcohol, but not for intoxication. You're not considered criminally intoxicated until you're 0.08. Okay? However, 0.02 is still going to get you arrested for a violation. It's not.
What would be the violation?
It would be impaired. Driving while impaired.
Driving while impaired. Okay.
So it would be a violation. It would still be a DWI violation, but it's not a crime. Okay? It's still can be very, you're still going to get arrested. You're still going to have a case. It's going to be a violation. It's going to be looked at a little bit less strictly, but it's still a case. Now, you lose about 3/4 of a drink. 75% of your blood alcohol is reduced per hour. Okay, so you want to say, if I have 4 drinks, I want to wait 5 hours after them if I have them all in one shot. You want to calculate the amount of time. If it's between shots, you want to think about that. But you want to give yourself enough time to sober up before you get into a car. But you also have to calculate that it takes about 25 minutes to get into your blood alcohol content. So if you're going to have 4 drinks, you better get comfortable if you're going to get into a car.
What are the penalties, Counselor? A person is 0.08. You're arrested. What happens from there? What is the procedure?
So it's it's equivalent to an A misdemeanor. Okay, it's an unclassified misdemeanor, but it's equivalent to an A misdemeanor, and I say that because a person could potentially sit for a year in jail for driving while intoxicated. Okay, Typically, if it's a first arrest and if there's other mitigating factors, they won't be given the most strict, case. But if the person denies it and goes to trial and gets convicted and there were injuries and there's a lot of aggravating factors, then they may very well be looking at some serious amount of jail time. On a violation, I believe the maximum they can give you of jail time is 15 days.
15 days.
So there are rights that people can have at the time when they're stopped. So, I have people come to me all the time, say, hey, if I leave this wedding right now, when I waited and I sobered up and everything's fine, but I'm still a little bit scared because maybe there's something on my lips or maybe there's not, I get stopped by a cop. What should I do? So obviously if a person is completely sober, didn't have anything to drink, is okay. They don't lose anything by blowing because it's at the scene, even though it's not admissible at trial, but they will still be able to walk away from that car stop and just not have any hassle.
Right.
If they are completely drunk, then it doesn't matter if they blow or they don't blow. It doesn't matter if their attorney comes or doesn't come. They're going to get arrested, they're going to go down, and their license is going to be suspended. The only question comes is that, do you have to blow? Okay? The answer is no, you don't have to blow.
How about the other, standing on one leg and stuff like that? Is that also?
So that's the second part of this is when they finally go to the precinct, right? And they have to blow, they're expected to blow a second time, right? At that point, what a lot of people do, and I think smart people that are already, that means at the scene, that means you were already arrested. If you're in the precinct blowing the second time, or maybe even if the person refused the first time, and now they're in the precinct asking them to blow, and they're asking the defendant on video camera, do you refuse? He has three choices. Option number one, to blow at the precinct. Option number two, to refuse to blow, license suspended, case proceeds. Third option is say, I'm not refusing. I am clearly not refusing, but I want my lawyer to be here. Now, if the lawyer can be there quickly, that's great. Then he can make a decision together with the lawyer whether he should blow or not, and the lawyer can advise him based on the specific circumstances. But a lot of times it takes a lawyer a long time to get there, or a person can't get through to his lawyer. And then what that does is it allows for there to be this lag of time where he's kind of sobering up, and then the police can't get really an accurate, after a certain amount of time passes, a few hours, they're not getting an accurate blow anymore. And at that point, they may have to, their evidence is not going to be as strong against them. So the officer might say, too bad, we're not waiting for your lawyer, proceed with the arrest. But at least they had on record that they requested their lawyer and they didn't actually refuse, but they asked for their attorney.
Well, listen, Counselor, we got so much information here today. We want to have you back.
Thank you.
When we get great guests, we always want to have them back, and we look forward to your legal clinic. I heard that you're going to do some outreach to the community and run a legal clinic, and we look forward to that. And Thank you so much for great information. Humility. Is that?
Humility, that's
humility
the key.
is the key.
That's the key.
Thank you, Counselor.
Thank you.
Appreciate it. And thank you for joining us once again. Always reminding you, take care of yourself. More importantly, let's take care of each other. See you next time.